Hello, hello, everyone. Maria Bermudez here, attorney with Disability Advocacy Group. Can you let me know in the chat? Is anyone here? I hope you're starting your day off good, depending on where you're at. Should be 8 a.m. Eastern. And I'm just jumping on this live to answer any questions that folks might have about the government shutdown, how it might impact or not impact your benefits, and answer some frequently asked questions, which has been the theme of the year this year, frequently asked questions. So if anyone's on the live and wants to ask a question or just say hello, feel free. Chat's open. Let's see. All right, so let's get started. Most of you know that there was an announcement that the government has been shut down in terms of non-essential services with respect to at least Social Security in terms of impact. So what do claimants and people who are receiving benefits need to know? The main thing is that there should not be any interruption with ongoing benefits. The funding for Social Security disability benefits is established through a different source. So the current funds that are at issue with respect to the shutdown wouldn't have an impact on the Social Security disability claimants and their ongoing benefits. So that's the most important thing that most people want to know about when it comes to government shutdowns. So historically, that hasn't been an issue. Where where issues do come in are more so with respect to non-essential services. So for example, if you request a benefit verification letter or something like that, then that could take more time because that's considered something that's non-essential. Are they still processing claims? The answer to that is yes. Social Security will still be processing claims. However, it's very common for there to be delays when these things happen because there's not as much staffing. So it's possible that the time period that you will have to wait for your claim to be decided can be a bit longer because of the government shutdown. However, the primary thing that most people do ask about is, am I going to continue to receive my direct deposits? Am I going to continue to receive my benefits? And the answer to that question is yes. As far as we know, and historically, that has been the case. So to anyone who's currently receiving benefits, I hope that provides some comfort. And again, if you are applying for benefits, they are continuing to process claims. It just may take a little bit longer for things to get done and things to get processed. So again, if anyone has any questions, please feel free to drop your questions in the chat. And if not, we are going to go through some frequently asked questions. And I'm going to go through specifically the 8 different areas of case processing as a disability attorney. So I'd like to start off with the first one, which is our prospective case management, right? So, and this is something that I work on all the time as part of my practice, and that's welcoming new people who are prospective clients into the practice and assessing whether their case is something that we can help with. It's what we call intake internally. So when someone reaches out to us, and they want to see if it's a case that we can help with. Typically, they're telling us, listen, I can't work anymore. I can't support myself financially. I need help. So as a lawyer, what do we then do? And how do we assess the case? So a lot of people ask us, like, what's the basis of your decision? A claimant or a prospective client will ask, what's the basis of your decision whether you're going to accept the case or not accept the case? And so it 100% comes down to Social Security's rules and regulations. And so what we do is we compare an individual, prospective client, a person, their individual circumstances with what Social Security's rules and regulations are. And based on those two things, an analysis of the individual and the rules, we decide if we think that it's a case that is likely to be awarded. And in that case, we would get involved and assist. If it's a case where we do not believe that we are able to get the case awarded, that is going to be a case that we would either decline, or maybe we would refer you to someone who may be a better fit. So that's the first frequently asked question, is with respect to prospective client or prospective cases. How do we make a decision as to whether or not we're going to be able to assist in a case? And again, we ask questions about the individual circumstances, the person's work history, their conditions, their treatment, et cetera. And then we compare that to Social Security's rules and regulations. And if we think that the case is likely to be awarded or the person may qualify, then we would get involved with their case. So moving on. The second part of case management with a Social Security disability case is what we call new client onboarding. So I'm just going to take a pause before going into new client onboarding to let anybody who's watching know, if you have any questions, please feel free to drop them in the chat. I'm going over frequently asked questions when it comes to Social Security disability law practice, and what are some areas that people have questions about when it comes to how we manage our cases. I also did address the current government shutdown and reassuring those who are currently getting benefits that this isn't likely to result in any sort of delay or pause in their ongoing monthly benefits. So, all right, moving forward, new client onboarding. So a frequently asked question that we get in new client onboarding is typically like, what is the process for becoming a client at Disability Advocacy Group? So first things first, representation forms. That's what establishes our relationship. So when we agree to take on a new case, we have the client and me as the attorney sign representation forms. So it's saying, listen, I'm going to represent you. You are my client. And then you have an agreement with me, which is that you're going to pay me. And that is what we call a contingency fee agreement. So you may have heard on like TV, and sometimes they say like, we don't get paid unless you get paid. It's the same type of deal, right? So like when we take a case, we take that risk. And if the client is not awarded benefits, then we don't get paid. If the client is awarded benefits, then we get 25% of the back pay. The client gets 75% of the back pay. And that's in the Social Security Act. So any lawyer that you hire, it's always going to be the same thing. There are different variations when it comes to fees. There might be certain situations where the fee structure is different. For example, if you hire more than one attorney, then they have to do petitions, et cetera. So there's different intricacies, but overall, based on the law and the norms, it's 75% of back pay goes to the client, 25% of the back pay goes to the attorney. And there is a cap on that. So for example, if your back pay is $50,000, the attorney, the most that they can get is $9,200. It used to be $6,000 a few years ago, and incrementally it's gone up the cap. So that's what people ask, is like, what does onboarding, entail? And that's what onboarding entails, is signing representation agreements, agreeing to work together and the terms that we're going to work together, and then getting to know each other through the process of getting your medical information, your background, your history, so that we can properly create a strategy for how we're going to work your claim through the process. So that's onboarding. The next step is the initial application. So after people come to us at different stages, right? Sometimes they already filed their own application and they come to us and they were denied and they need help with an appeal. So we'll file what's called a request for reconsideration appeal, or a request for hearing appeal, or an appeals council appeal, or a federal court appeal. So, but if they haven't filed a claim yet, then initial application for disability benefits. And what's involved with that is we have a series of questionnaires, and we go back and forth with our clients and ask them questions about their history. If they have their work history, if they have any history in the military, if they've been married before, of course, their conditions and treatment and that sort of thing. So there's a lot that goes into an initial application, and a lot of people can find initial applications somewhat overwhelming because they're asking you so many questions about your children, about your living situation. I mean, there's so much that goes into an initial application. And I try to reassure our clients that it is a lot. It's a lot up front. I mean, you never really have to give that much information again throughout the claim process. But I mean, what you're getting, if you are awarded benefits, you're getting this security every single month, many times for the rest of your life. Because when you get awarded Social Security disability benefits, it automatically rolls into retirement benefits. So an award for Social Security disability, it's a really big deal. And it's a wonderful benefit that our country has for people who need the assistance. So it is not an easy process. It is, it's, front loaded. It's definitely like a lot on the front end. And it can be a draining process. But once a person is awarded, many times they're awarded for a very long period of time. Of course, there are situations where there are continuing disability reviews. People can have their benefits terminated. However, in general, if a person continues to have their conditions and they're severe and they're not getting better, then the benefits are going to continue and convert into retirement benefits at retirement age. So with no penalty, which is great, of course. So that's the initial application. Frequently asked questions when it comes to initial applications are, well, what am I going to have to go through? Am I going to have to go through an exam? What other than the application, what do I have to go through? So people typically have to go through an exam. It's called a consultative exam, and it can be a physical exam with an internist, like a primary care doctor. It could be a mental health examination, sometimes both. It can be a specialized test. So, for example, if someone is alleging hearing loss or vision impairment, sometimes Social Security will send them for an exam specific to the condition that they're alleging. So those are, again, what we call consultative examinations. Additionally, Social Security many times is going to request that claimants complete additional forms as part of the initial application process. So this would include what we call function report, activities of daily living questionnaire, a work history report. They're going to be asking about what kind of work you did for the last 5 years. What were the requirements of that work? So these are just a few of the things that Social Security asks for during that time. A lot of people ask me, how long does this last? The initial application. So when you file for disability benefits, it can vary greatly how long the application takes to get awarded. It can vary based on your geography, where you're located. So, for example, I practice most of my cases are in Pennsylvania and New Jersey. I have some cases in Puerto Rico as well. But I do have a few outliers in different states. I would say Florida takes a really long time. Pennsylvania and New Jersey are averaging right around 9 months. So it really depends on where you're located as to how long it's going to take. And to answer that specifically, it would be best to talk to a practitioner in your area. So next is the appeals. The common appeals that we get, people call us and they say they were denied. So there's the reconsideration appeal, which is after an initial application is denied. And then if the reconsideration review is denied, then there is a request for hearing appeal. So the appeal forms themselves are pretty straightforward in terms of, what changes do you have? What are your new updates medically? People ask me a lot, like, what's the chances of getting approved? I will say for reconsideration, typically, more likely than not, we're going to see another denial. It's not uncommon to see another denial and have to go to the hearing level, which is the administrative law judge hearing. Now, at the hearing level with an administrative law judge, we do see things turn around. We do see cases awarded at that level. And there are very specific reasons for that. And there's something that's called judicial discretion. Now, this is important because a lot of times people get very upset when they're denied at the initial application level or the reconsideration level, and they don't understand why they have to go to a hearing. And the reason why is because a judge has different authority than someone that's assessing the claim at the reconsideration level and the initial application level. A judge has what we call judicial discretion. So they look at the medical records and they look at, everything that you're saying, and they can assess it, differently, right? They can use their own, discretion. So for example, if you say, I, can only stand for 10 minutes, this is what your testimony is, right? They can look at your medical records and they can see your physical examination findings. Some of them are, abnormal. Some of them are normal. And they can kind of weigh things and they can say, you know what? I believe that this is consistent with what he or she is saying. And I'm going to find that, they can only stand for 10 minutes at a time, right? So that capability is not there at the initial application level or the reconsideration level in the same way, right? So judicial discretion is a thing, and that's important. And that's why a lot of times claims have to go to an administrative law judge. It doesn't mean that you're not disabled or you're not believable. It just means that that's the process and they need that discretion to be able to decide the claim. So I'm going to pause just for a second because we have a question. And we have Books of Zaref, who is asking, who decides the doctor we see for the examination? That's a great question. And so that comes from the Department of Disability Determinations, it's a separate agency that Social Security outsources the disability determinations to, a state agency. Okay, every state has their own disability determination services. Sometimes they're called Bureau of Disability Determinations. So when you file an application, I'm going to backslide for a minute to explain this. You file an application, your case from the local office then gets sent to this disability determinations, this other agency, right? This state agency. And there you have an adjudicator, an adjuster, a caseworker, somebody who's managing your claim, right? They're reviewing all the evidence, the medical records to see that everything is in. They're reviewing your function report. They also have doctors there who are reviewing things. So they're the ones that decide what doctor you're going to see. Now, what's the basis? What are your impairments? That's what the basis is. So, for example, if you have your own doctor who's doing hearing testing and they've done recent hearing testing and that's part of the allegation of disability, then they may not send you for hearing testing. They're not doing it just to have an extra evaluation or report. They're typically doing it because something is missing or they're not clear about it. So it's very common to see physical ones like the internist ones that are just general physical examinations. It's very common to see mental ones, especially if somebody is alleging depression, anxiety, or any other mental health impairment. The specialized ones are typically if there's not something there and they need it to be able to make a decision. So, for example, if it's an orthopedic condition, arthritis, degenerative disc disease, and there's no X-ray, there's no MRI in the file, then it's possible that they're going to say, we need an exam with an X-ray, or, if there's a vision impairment alleged and there hasn't been a vision exam in a year, then it's possible that they're going to say, okay, we need a specific examination with vision testing. So we see sometimes pulmonary function testing. So those are the sorts of examinations, specialized examinations that we see when they don't have enough information or medical records to be able to see exactly what's going on with that condition to measure the severity and what the limitations associated are. So let me know if you have any follow-up on that, books, and I hope that answered your question. So, alrighty. So for anyone new that's on the live, we're just doing some frequently asked questions about how we manage Social Security disability cases and the process in general. I started out the conversation acknowledging that we have, a government shutdown right now, and assuring anyone who's currently receiving benefits that historically this has not impacted ongoing claims. People continue to receive their benefits as those financial resources are not part of what's at issue for the shutdown, those funds. So, okay, so moving forward, we were talking about the administrative law judge hearings and why someone would have to go. And I was explaining that because of judicial discretion a lot of times. So let's talk a little bit about, people ask me, like, what do I need to know? How do I prepare for a hearing with an administrative law judge? And it is very important to be prepared and to know what to expect when you're going into a hearing with an administrative law judge. It's a big deal. This person, once you get a decision from an administrative law judge, it's a big deal both ways, right? So if it's in your favor, it's going to lay out all the reasons why you are disabled according to Social Security's rules and regulations. Now, on the contrary, if they deny the claim, they're going to lay out all the reasons you're not disabled. So then that does have an impact, right? If you're going to apply again in the future, because now you have a 10 or 15-page decision that says all the reasons why you're not disabled. So for that reason, it definitely is something that we take seriously. And of course, we recommend to claimants that they take seriously. It's my opinion that having an attorney represent you at a hearing is likely to be in your best interest. And there's a number of reasons for that. One of the reasons is because the goal of preparing a file is that everything that you've done in terms of treatment, the judge has access to. Now, this means that before your disability date, a year before your disability date, you have all your medical records inside that file so that the judge can properly determine what your conditions were and are, what the limitations associated with those conditions are, and be able to assign restrictions and limitations, or see if under Social Security's listings you qualify for disability benefits. So having all of the records and having someone that has access to what the judge currently sees and what's missing is a pivotal part of the preparation process. Additionally, you'll want to know what to expect at the hearing. Now, I do have a video about it, and I try to be pretty comprehensive to explain to you exactly what to expect when you're going into a Social Security disability hearing. But in short, there's three main parts. One is what we call housekeeping, right? The technical aspects like swearing you in, talking about evidence, confirming the method of the hearing, whether it's video or phone. So the housekeeping, technical aspects of the hearing, making sure the record's complete, that sort of thing. The second part of the hearing has to do with testimony, the claimant testimony. If you have an attorney, they may question you sometimes whether or not you have an attorney, the judge is going to question you. It depends on the judge's preference. And then the last part of the hearing is what we call vocational witness, or Social Security calls them vocational expert testimony. So this is someone who is trained in the Department of Labor's Dictionary of Occupational Titles and other vocational, which is like jobs that exist in the country. And so they will testify as to whether or not there are jobs that you could potentially do. So that's the three main parts of a hearing, and understanding that and understanding what each part means is obviously very important, so that you can be calm when you're going into it, feel prepared, and be able to testify and explain to the judge exactly what it is that you're going through. And I also have a video on that as well, is how to communicate with Social Security using their language, right? Because Social Security communicates in terms that include frequency and duration. So, right, like when you're explaining your limitations to Social Security, they want to know how long, duration, how often, frequency. So, for example, I used in my video the example of headaches. So, it's very different when you ask someone, okay, you said you have headaches and you have a hard time working because you have headaches. Well, how often does this happen? Oh, I don't know. It happens a lot. It's really bad. I have to lay down. It's so bad. That's very different than someone testifying and being like, I get headaches at least twice a week. They're debilitating. I have to go into my bedroom for a minimum of 2 hours. I have to take medication as soon as I get a headache. It takes, 2 to 3 hours with everything closed off and dark. And then the medication finally hits, but then I'm still very tired. Sometimes I get nauseous, etc. So like that is like a way that Social Security understands, because you're addressing how often and how long these things impact you. And then this way they can compare it to, okay, well, how would that impact someone's ability to work? Well, how would it? Well, if somebody has a headache for, twice a week, and they are, in bed unscheduled for 2 hours each time, most jobs are not going to let you just take an unscheduled break for 2 hours twice a week. Not a full-time job is typically not going to allow you to do that. They maybe accommodations, which that's something different. But anyway, that's how Social Security looks at it. And of course, everything that you say has to be backed up with medical records. So in a situation like that, you would be hopefully treating with a neurologist or a headache specialist who has documented over time that is in fact what's happening, and you're getting medication management or whatever sort of therapies that might be helping with that. So I did kind of go off a little bit on a tangent. So, but that's what you can expect at a hearing, and that just kind of gives you a little bit of my thoughts on how to communicate with Social Security, whether it's testimony or filling out paperwork. It's always important to remember that they're looking at things in terms of frequency and duration. And one kind of thing that people do that I recommend is to keep a journal that will help you to be able to answer things in frequency and duration. So if you're keeping a journal of your symptoms and you're writing down whether it's panic attacks, headaches, back pain, spasms, even use of ambulatory device, which we call like a cane or a walker. Like sometimes Social Security will ask, or a judge will ask, like, okay, well, how often do you use your walker versus your cane? Like you can journal that throughout the process, even if you're only journaling for a month or 2 months. You can submit it if you'd like, but you can also have that as a point of reference for yourself. Like, okay, this week I had to use my walker 3 times because I was having a flare versus using my cane, which is what I usually use, something like that. So keeping a journal can definitely help in your ability to articulate and explain to Social Security what you're going through on a regular basis. So that's a tip for you. All right. So moving forward. Next question I get is, what happens after an administrative law judge decision? So, if you are awarded disability benefits, then you'll go into the payment cycle, right? Like you get the decision, it goes to the local office, and then they start you in the process of getting paid monthly benefits and your back pay and all that. If you are denied by an administrative law judge and you get a decision saying that you're not eligible for benefits, then the next step is the appeals council. And so what the appeals council is you don't have, they're judges, you don't have to go in front of them. So if you have an attorney and you file an appeal to the appeals council, they will explain the legal basis why they believe, according to Social Security's rules and regulations, the judge's decision was wrong. You can also do this if you don't have an attorney. You can explain why you feel like the judge's decision was wrong. Having an attorney, they're typically going to rely on policy. They're going to rely on Social Security's rules and regulations, and so they're more specific as to, the basis for the appeal, the legal basis for the appeal. So what happens is the appeals council, and this can take, generally for my cases, it's between 9 months and 12 months. For an appeal of a judge's decision, an administrative law judge's decision. And so what the appeals council will do is they're going to review the record, they're going to review the arguments and the judge's decision, of course, and they're going to make a decision as to whether they're going to, agree with the ALJ and say, we don't see any reason to question this decision, it was within their discretion, or they may do what's called a remand. They can send the case back. So that's what we consider to be a win. If the appeals council remands a case, that's a positive decision. So it'll go back to the judge and we'll have a new hearing and have a brand new decision. So in that situation, typically it goes back to the same administrative law judge. And then people ask me, well, like, are they going to overturn their own decision? Yeah, sometimes they do. Sometimes they don't, sometimes we go back and forth more than once, with appeal, and then have a new hearing and then have to appeal again. So it can definitely be a process, but yeah, so that's what's considered a positive decision. Now, sometimes people ask me, does the appeals council ever outright award a case and say, the ALJ was wrong, we're going to award this case, this person gets benefits? Is it possible? Yes. Extremely rare, though. Extremely rare. At the appeals council level, one of two things is going to happen. You get denied, and then you have the right to go to federal court, or you get a remand, which means you get a new hearing either with the judge that issued the previous decision or a new judge. Sometimes a new judge gets awarded, especially if you've been back and forth appealing. So let's talk about federal court then. So there is the option, if you get denied by the appeals council, to file a complaint in federal court. And so at this stage, you most certainly would want a lawyer. You don't have to have it. You can file pro se, which means you can file by yourself, but you're filing a complaint against the federal government. To be clear, you're filing a complaint against the federal government. And so what that complaint is based on, it's saying that the administrative law judge, you don't agree with their decision, and there has to be a legal basis for you to file that complaint against the federal government. They had to have done something. You can't just file it and say, I disagree with the judge's decision. There has to be a legal reason for bringing the case to federal court. So what we do in those cases is we file the complaint. The government files a response, which is just filing the record. It's not any sort of substantive response. Their response is filing a copy of the administrative record, which is all your medical records, all the notices that were, in the claim, and anything else, letters, briefs, whatever, the entire period from the initial application until through the appeals council denial. That's what the government is going to file as their response. And once they do that, then it sets the timer for briefing. And so what we have to do as the claimant's attorney or plaintiff's attorneys is we have to file a motion for a request for review of the administrative law judge's decision. So in other words, we're asking the federal court judge to say that the administrative law judge was wrong and that the case should be sent back to Social Security for a new decision. So in those cases, the briefing is based on the established records. No new medical evidence comes in. It's, whether your file is 800 pages, 1,000 pages, 2,000 pages, that's what we're writing. So depending on the jurisdiction, it depends on the format of the brief. So we typically lay out a chronology of the medical history, and then we make our legal arguments. We pick, the key legal arguments, and we're explaining why, according to Social Security's rules and regulations, the judge's decision was not correct. And we can also, in federal court, rely on case law. Case law is other cases. So if there's a person 5 years ago, say your case is based on lumbar degenerative disc disease, and there's something specific about your case. So then we're going to look for cases that have similar facts, and then what the judge said in that decision that could potentially help us in this case. So, and that goes for different issues. So for example, like if you're saying that you would be absent from work, because of your condition, if they didn't properly consider, your age as a factor, there's a number of different legal arguments that we use case law to help support the briefs, in addition to Social Security's rules and regulations. So that's how we argue in federal court. Now, we file our brief, Social Security's attorneys get to file a response, and then we get to file a reply to their response. So we go back and forth with motions and briefs, and then ultimately a federal court judge decides whether to affirm or agree with Social Security's decision, or send the case back to Social Security and agree with us that the decision was wrong. So that is federal court in a nutshell. Next would be, and the last topic is case closing. So how do we offboard our clients? So at every single stage that we talked about today, there is the chance that someone could get awarded or denied and have to go through an appeal. So whether it's an initial application, reconsideration, ALJ level, those are the two outcomes, whether it's, positive or negative. Eventually, if a person is awarded and, we're ready to close the case down, what does that look like for our practice? So we provide resources. So explaining to our clients, okay, this is what happens next. This is what you can expect next. You're going to get this notice of award. You're going to, if it's SSD, you're going to be eligible for Medicare. If it's SSI, Medicaid. If it's SSI, you're going to have to go through what they call a perk interview with Social Security. So we explain what happens next, and we provide them, our clients, with resources as to, what the next steps are. And then they're going to be largely working directly with Social Security moving forward. Unfortunately, attorneys don't currently have any access to payment information, scheduling, that sort of thing. So that's directly between the claimant, the recipient of Social Security benefits, and the Social Security office. So we will make sure that you're getting your benefits, meaning like actually they're coming in. You've got your notice of award explaining exactly how much you're going to get and when you're going to get it, and provide any resources that you may need moving forward. And then we close the case out on our end, and that's the end of our relationship. So those are the main steps of a Social Security disability claim and our relationship with our clients as part of managing a Social Security disability claim. So if anyone has any questions, I covered a lot of different topics and areas today. Please feel free to put your questions in the chat, and I'd be happy to answer any questions that you might have about the Social Security disability process or anything else related to a claim. Let's see. And for anyone who is just now joining, um, as far as the government shutdown, I started off this live talking about the acknowledging that the federal government's currently at this point in a shutdown, and that as far as we know historically, and we believe to be the case at this point, there's no interruption in benefits for Social Security disability claimants. They're still going to be processing claims as well. Now that could be delayed due to staffing. So a claim could be potentially time for them to make a decision could be potentially longer. However, they're still going to be processing claims. There's some non-essential services that may take longer. So for example, if you need a benefit verification letter or something like that, that could understandably take longer due to staffing issues. But overall, Social Security will continue functioning in terms of benefit payments, and they will be processing claims. One of the best ways that you can get information about your status and in general with respect to a claim is by creating, if you don't have one already, a My Social Security account. You can see a lot of information there. You can pull a verification letter, and you can pull your record by having a My Social Security account. So we encourage everyone to, if you don't have one already, go to ssa.gov and create an account to help manage your benefits, to help manage your claim. So any questions? Well, it was a pleasure meeting with you all today. I think this is my first live that I've ever done, and I'd like to welcome any new viewers. Oh, thanks so much, Books as Ref. Thank you so much. This is my first live. I look forward to doing it again. I hope it was helpful for anyone that was able to tune in. And my name is Maria Bermudez. I'm the managing attorney at Disability Advocacy Group. We help people apply for and manage claims for Social Security disability benefits and long-term disability benefits under private policies. It's the only thing that we do. And we help with claims throughout the United States and territories, Puerto Rico specifically, but we can help in the territories as well. And federal court cases, we only take in Pennsylvania, New Jersey, and Puerto Rico. Other cases, if someone comes to us, we refer it to a colleague. But you're more than welcome to reach out at any time if you'd like a complimentary case evaluation if you're interested in applying for disability benefits. So again, I hope you found this to be helpful, and I look forward to catching you guys on the next one. Take care.